Namaste. Good afternoon to one and all present here. I, Sabiha Khan, Assistant Professor at School of Law, Raffles University, Nimrana. On the behalf of entire Raffles family, I want to welcome our speaker, Professor Russel Sandberg, Chief Partner, School of Law, Revered Dr. Justice Meena V. Gomber, Dr. Divakar Goli, the President of School of Law, the President of our Raffles University, head of different schools of Raffles University, my fellow colleagues, students, ladies and gentlemen. In this fast-growing world, there are theological issues with regards to religion. There are societal issues with regards to marriages. And there is a lacuna in our legal system. So in order to highlight, direct, and to share his wisdom and knowledge, I want to briefly introduce our speaker. So Professor Sandberg is a professor of law at Cardiff University, United Kingdom. His research interrogates the interaction between law and humanities with particular expertise in law and religion and legal history. He is the author of Law and Religion, Cambridge University Press, 2011. The first textbook in the field, Religion, Law and Society, Cambridge University Press, 2014, which explored the interplay between the legal and sociological study of religion and marriage law. The Need for Reform, Bristol University Press, 2021, which provides the first accessible guide to how contemporary marriages law interacts with the religion, identifying pressure point and setting out proposal for reform and supervision legal history. A manifesto for the future of legal education, Raffles 2021, which argues that history should be at the beating heart of the law curriculum. For more details about our speaker, you can also browse his website and blogs. So without any further delay, I would like to invite and hand over the session to our guest, Professor Sandberg. Over to you, sir. Please unmute, sir.
Yes, I've unmuted. Excellent. I've not used Google Hangouts before, so chances are I might do a couple of things which are technologically unsound. But first, thanks very much for the invite. It's an absolute pleasure to be with you this afternoon in your time, this morning in my time. I'm going to go through a presentation of some of the main ideas in the third book, which you just mentioned, which has just come out with Bristol University Press. I should also say that because of COVID, I'm working from home, and we have some building work going on outside, or should have some building work going on outside if the builders turn up today. So if there is a noise later, I apologize for that, but at the moment they haven't turned up. So at the moment everything is very quiet here. Right, I'm going to try and share my screen. Excellent. Can you see my screen now, or can you still see me? Oh, hang on.
Yes, sir, we can see both.
You can see both. Excellent. Fantastic. Let me just put the slides on. I can't see you now is the issue, but that's okay, I think. You'll just need to speak to me if you need to tell me anything, because I can't actually see you. If that's okay? Excellent. Shall I begin?
Yes, sir, please.
Yes, excellent.
Yes,
I didn't want to be talking and not be on the call. Right, okay. So, as I said earlier, I'm talking about this new book, which is about religion and marriage law, the need for reform in England and Wales. That's going to be the focus geographically of what I'm going to be talking about. And England and Wales is part of the United Kingdom, but in the United Kingdom, there are different legal systems in different nations. And so what I'm going to be talking about today is England and Wales, and I'm going to take you through some of the arguments in this new book, which was published a couple of weeks ago. by Bristol University Press here in the UK. And in particular, I'm going to be focusing on the subtitle of that book, The Need for Reform. Why is it that our law on marriage in this country needs to be updated? Now, as we already heard in the introduction, actually, the reason is that the relationship between law and society and societal needs has broken down. There's a difference here in terms of the social reality of adult relationships and English and Welsh marriage law. So let me just begin by explaining what that social reality is. And please don't worry, most of the slides are nowhere near as detailed as this one. But what this slide is basically telling you is that the number of people getting married in England and Wales is declining significantly. So the first bullet point there tells you that by 2017, the marriage rate, the number of people who are married per 100,000, had decreased by 75% for men and 69% for women since 1972. It's now the lowest on record. And the number of marriages by opposite-sex couples has also decreased by 45%. And what's also striking is that there's been an even more dramatic decrease in terms of the amount of religious marriages. So whereas in 1900, religious ceremonies accounted for 85% of all marriages, they were half of all marriages, as under half of all marriages, by the late 1970s. And by 2017, only 22%. And indeed, civil marriages, and by civil what I mean here is non-religious marriage ceremonies, have outnumbered religious marriages every year since 1992. At the same time, the number of people cohabiting, so living together without getting married, has increased dramatically. It was 1 in 10 women, 1 in 10 of non-married women in 1979. It's now over a third. And when you look at those aged between 16 and 29, it's 69%. And the issue is that in this country, we've got what's called the common law marriage myth. And what I mean by that is there's a myth that people think that if they live together as husband and wife without getting married, they would get the same rights as married couples. And that's a myth because that simply isn't the case. Under English law, there are no rights for cohabiting couples based on just living together. And surveys have shown that almost half of people think that there are such rights, when actually there are not. So the common law marriage myth, the idea that if you live together over a certain amount of years, you get the same rights in law as a married couple, is simply not true. And by the same rights, what I'm talking about there is basically you can have recourse to the state and recourse to state law if the relationship breaks down. So the law on divorce, which allows couples to go to court, which allows the state to intervene and deal with financial matters, does not apply in relation to cohabiting couples. And this is more of a problem because now a number of relationships exist outside the law. They exist outside the Marriage Act 1949. These include cohabiting couples, as I've been saying. If you cohabit in England and Wales, you have no rights under marriage law. It also includes what I would call unregistered religious marriages. These are people who have got married religiously in the eyes of their faith, but they have not complied with the Marriage Act. They have not complied with state law on marriage. It also includes non-religious belief marriages, people who get married under the auspices of a belief organization, such as the Humanists, or use an independent celebrant. Those ceremonies too are not legally binding here, and so the couple are not legally married as a result of that ceremony. Now, of course, all three sets of couples could get married legally by also having a marriage under the Marriage Act 1949. But they might not. And until they do, and unless they do, their marriages are not legally recognized by the state. And this afternoon, I'm going to focus on these second two types, unregistered religious marriages and non-religious belief marriages, and what the situation is in England and Wales and why there is a need for reform. There are different issues here. In relation to non-religious marriages, so marriages by humanists, marriages by by independent celebrants, other belief organizations, there's a gap in English law. Under English law, there's no way in which their marriages can be legally binding on their own. By contrast, in relation to unregistered religious marriages, there is no gap in the law. All religions can conduct marriages under the Marriage Act 1949, but there are different requirements for different religions. And some of those requirements, I would argue, indirectly discriminates against certain religions in ways that I will be explaining shortly. So this is a summary of the current law in England and Wales. So the Marriage Act 1949 makes a distinction between marriages solemnised according to the rites of the Church of England, which include the Church in Wales, and marriages otherwise solemnised. Now, Church of England, Church in Wales is a Christian church. It's an Anglican church. And in relation to the Church of England, it's also a state church. It's an established church, by which I mean there are constitutional links between the English state and the Church of England. And those constitutional links are many. It means, for instance, that bishops of the House of England sit in the House of Lords, where legislation is made. It's one of two parts of our Parliament, House of Commons, House of Lords. Bishops of the Church of England sit in the House of Lords. The law of the Church of England is part of the law of the land, and it is often understood that there is a legal right for people to get married in the Church of England churches. Church in Wales is also an Anglican church. It used to be part of the Church of England, but in 1920 it became disestablished. So most of the links between the state and the church in Wales doesn't exist anymore, but in relation to marriage they still do. So in relation to marriage, the Church in Wales is in the same position as the Church of England. So marriage law in this country distinguishes between marriages conducted by the established church and all other marriages. And then if you look at that category of all other marriages, there are four different types. First is civil marriage in a registered office or approved premises. This is basically marriage conducted by a civil servant in a government building or in a building that has been approved by the government. Those marriages cannot be religious. You cannot use any form of religious service at those ceremonies, and basically you have to follow the requirements under state law. The second category is the Society of Friends, Quakers. The third category are Jewish weddings. Now, the reason why Quaker and Jewish weddings are mentioned by name in the statute is purely historical. The law on marriage in this country dates back to 1753. 1753. And at that point, it was only Church of England weddings that were lawful. But the statute recognised that because Quakers and Jews were tolerated under English law, the statute didn't apply to them. Now, since 1753, numerous other religions in this country have been recognised and tolerated. We don't have a written constitution. We do not have a civil or criminal code. We do not have laws that outline which religions are recognised and regulated. But over the centuries, a number of religions are now recognised. And the test for marriage law is the fourth category under the Marriage Act 1949. Marriages in any place of registered worship, so in a registered place of worship, are or can be legally binding. So, under English law, if you're a member of the Church of England, your marriage, and you get married in the Church of England, your marriage is legally binding. If you're a Quaker or a Jew, your marriage is legally binding. If you're of any other religion, your marriage is only legally binding if it takes place in a registered place of worship. And that rule causes considerable hardship because there's a tradition in some communities of not getting married in a place of worship, or indeed not having a place of worship. And I would argue that that rule indirectly discriminates against some religions. You will notice there is no category there for humanists. There is no category there for non-religious beliefs. They simply cannot get married under the Marriage Act 1949, and that means that if they get married, it is not legally binding unless and until there is a civil marriage, so category 1 on the slide. So there are different issues here in terms of the problem. There are different issues in terms of non-religious marriages and unregistered religious marriages. Whereas for non-religious marriages, there is a gap in the law. You simply cannot get married under Marriage Act 1949 in a way using a humanist ceremony, for instance. In relation to unregistered religious marriages, there is no gap in the law, but the law indirectly discriminates. The effect is the same. Marriages are not legally binding if it's a non-religious marriage or if it's an unregistered religious marriage. So if you want a legally recognized marriage, you need a civil ceremony. That, of course, means that you're spending out twice. That means there's inconvenience. That also means that numerous people forget or do not know that they need that separate ceremony. That poses a problem if the relationship then breaks down, because that poses a problem because if the relationship breaks down, they are not entitled to legal support. They are not entitled to state law on divorce. They are not entitled to state law on financial provisions. And this is a particular risk if it is not an autonomous and a voluntary choice on the part of both of the parties. if I don't know about the law, if I don't know about the requirements, or if I want to comply but my partner doesn't want to comply, then that leads to unfairness and hardship. So this afternoon, I'm going to talk a little bit more about these two problems, the problem of unregistered religious marriages and the problem of non-religious belief marriages. And then I'm going to talk briefly about some possible solutions, talking about the themes really of my new book. So in terms of unregistered religious marriages, what are the reasons why people don't register their religious marriages? It might be because the law is complex or restrictive, in which case I would argue we need law reform in order to reflect matters of religious freedom. There may be a choice not to get married civilly. People might want a religious-only marriage. That's true, for example, of some observant Muslims, who often just have a nikah, a Muslim wedding ceremony, so they can be together without being chaperoned. It allows them to date without someone else being there. They don't want, at that point, a full legal marriage. It might result from an awareness of what the law is. And I would argue, if that's the case, we need further education. We need increased awareness. Or it might not be a voluntary decision on the part of one or more of the parties. Now, concern about unregistered religious marriages has been raised by several studies in the last 10 years or so, one of which was a Cardiff study which I was involved with. And that was the first study in this country of religious tribunals, a comparative study of religious tribunals, looking at a Muslim Sharia tribunal, looking at a Jewish Beth Din, and looking at a Roman Catholic marriage tribunal, and comparing the activities of them and looking at how that fitted in with state law. And we found in 2011 that about half of those cases being dealt with by the particular Sharia council that we were studying involved people who were not married under English law. And we said that was problematic because that meant that they had no choice other than to use the Sharia tribunal, Sharia council. They couldn't go to state law. Numerous reports in recent years in the country have highlighted the same issue. This was a commission set up a few years ago which highlighted exactly the same issue as I've just been speaking, saying that basically those who have entered into a religious-only marriage are in the same legal position as cohabitants. Similarly, an independent review said that a significant number of Muslim couples were in that position. There was also a bill put before Parliament in order to deal with this issue. The Marriage Act 1949 Amendment Bill was put before Parliament last year. And this would have made it a criminal offence to knowingly and willfully solemnize a marriage which was not legally binding. So this would have made it a criminal offence for people to act as celebrants of marriages which were not legally binding. Now, I've argued in the book and elsewhere that this was a bad idea in terms of law reform. And actually, the bill has now, there's a new session of Parliament and the bill hasn't been put forward in this session of Parliament. So this bill is pretty much dead. But a number of people argue that this is the way to deal with unregistered religious marriages. And I argue that it's not the way to deal with it because it focuses on the wrong thing. It ignores the reasons why religious marriages may not be registered. It's not the major issue. The major issue is not that celebrants, that imams, priests, etc., are deliberately failing to register marriages or are deliberately misleading couples. That's not the problem here. That's the problem the bill would solve, but that's not the problem in reality. The problem in reality is that some couples are deciding, either deliberately or accidentally, to have a religious marriage that does not comply with the Marriage Act. So if you look at those reasons I discussed a few minutes ago of why people might not be registering their religious marriage, you will see that in any of those situations, using the criminal law against a celebrant, assuming you can identify a celebrant in the first place, does not deal with the issue. So locking up or fining imams is not the way to deal with this issue, I would argue. Another way put forward in the courts in recent years was to deal with it by reinterpreting the law on validity. So the case of Akita and Khan concerned a typical unregistered religious marriage. The couple had a nikah ceremony and always then intended to have a civil marriage, but never got around to it. And indeed, the husband was increasingly reluctant to get married civilly. They split up, and the wife took the case to court, suing for divorce. As he was told, you can't have a divorce because you're not legally married. Your marriage was not valid. You have no valid marriage. But at first instance, the family court judge said, Mr. Justice Williams, Lord Justice Williams, said that the marriage had been void, and so there had been a marriage, but it had been void, and so she was entitled to state redress. The case then went to the Court of Appeal, and you can see the Court of Appeal decision on the left-hand side of your screen. And at the Court of Appeal decision, Lady Justice King and Lord Justice Moylan said, no, this was not a void marriage. This was a non-qualifying ceremony. What happened was outside the Marriage Act completely. A void marriage is where the Marriage Act is not completely complied with. In this instance, this was not a ceremony under the Marriage Act at all, and so there were no legal rights for the couple. Also in recent years, the Law Commission, now that's the government body that looks at reforming the law in England and Wales, has looked at the matter of marriage law. So in December 2015, they published a scoping paper which looked at what needed to be done. They concluded that marriage law was in need of reform. And one of the reasons why they said marriage law was in need of reform was this problem of unregistered religious marriages. And then last September, in September 2020, they published a full consultation paper outlining how they would reform the law. And they're currently working on their final report. And so we're expecting in this country this autumn there to be a debate, really, a public debate in terms of marriage law, and that's why I wrote the book. The book is intended to feed into that debate, and the book looks at the consultation paper. What do they propose in this consultation paper? They propose a move away from the focus on buildings and a move away from different rules for different religions. They say instead, for all legal marriages, there would need to be an officiant. They wouldn't necessarily need to be the celebrant. They would just need to be someone at the wedding. And it would be up to the officiant to agree to the form and the ceremony for the wedding. So they would decide how the couple get married. That could include being married anywhere. It wouldn't have to be in a building. It could be outside. And the Law Commission suggests that the only requirement would be that there would need to be consent by both of the parties. Now, in relation to the problem of unregistered religious marriages, I think the Law Commission's proposals, and I argue this in the book, a picture of which is now on your screen, I argue that this would mitigate, this would lessen the problem of unregistered religious marriages, because this would remove the requirements that indirectly discriminate against some religious groups. This would mean that you would no longer have the requirement that there needs to be a building, that there needs to be a registered place of religious worship. And I think if you get rid of that requirement, then more religions and more religious adherents would be able to marry under marriage law. Because it would get rid of those unregistered religious marriages that exist because of the strictness of the law, or because the couples are not aware of the requirements. And so they, get married in a place of worship that is not registered, or they get married outside, or they get married in another community building. But some unregistered marriages would still exist. If you didn't have an officiant there, your marriage would still not be legally binding. And in some cases, that would still not be an autonomous or free choice on the part of the parties. For instance, the Akatar and Khan situation, that would still be an unregistered religious marriage, because there was no officiant at their nikah ceremony. So, what about our second problem? What I'm calling the problem of non-religious belief marriages. The extent to which humanists, other forms of non-religious belief, and independent celebrants can conduct legally binding marriages. Well, as I said at the moment, the situation is very clear and very harsh in that they simply cannot conduct legally binding ceremonies under the current law. There's no means by which they can conduct legally binding ceremonies under the Marriage Act as it is currently drafted. So ceremonies solely conducted by belief organisations and independent celebrants are outside current marriage law. And there are thousands of these ceremonies taking place up and down this country, particularly at the moment because of the COVID restrictions meant that marriages couldn't take place for most of last year. And so getting a civil ceremony is difficult. They're all booked up. And so there are many, many couples, as I speak, getting married, as they see it, on beaches, in various different buildings, outside in various different places where they've got an independent celebrant or a humanist conducting the wedding, and that marriage is not legally binding unless and until they also have that civil wedding. Because they do not fall under the requirement, because they do not have a place of worship registered. Unless, of course, they go and use somebody else's building, which is perfectly open to them. That would be perfectly lawful for them to conduct their wedding ceremony there. So, how then is this term place of religious worship defined under English law? Because we could get around it if we defined it as place of religious worship and place of belief ceremonies. Because, as you know, international human rights law, in terms of the UN, in terms of, for us, the European Convention on Human Rights, talks about freedom of religion or belief. And it's possible to redefine provisions which talk about religion as saying, we interpret that now as talking about religion or belief. But that's not the way in which English law on marriage has gone. So our major case on this was a case in 2013, the Hodgkin case, where this concerned the Church of Scientology and whether a building used for Scientology could be registered as a place of religious worship. And the Supreme Court, the UK Supreme Court in this case, held that it could, because they said Scientology could be a religion for the purpose of registration law. And they said, Lord Tolson said, that was because religion could be described as a spiritual or non-secular belief system. But he said this did not need to extend to other belief systems. This did not need to extend to non-religious belief systems, because he said there were other means by which you could have a you could have a secular marriage. But the only way you can have a secular marriage is if it's a civil marriage, if it's a marriage conducted by civil servants. You cannot have a civil marriage conducted by a humanist celebrant. And so the humanists point out that means you cannot have a humanist wedding. They point out that a humanist wedding differs from a civil wedding in that it is entirely handcrafted and reflective of the humanist beliefs and values of the couples, conducted by a celebrant who shares their beliefs and values and can take place in any venue that is special to them. You can have a civil marriage in England and Wales, but it needs to be conducted by a civil servant in a government building or in a building which has been authorised by the government. And then the ceremony itself needs to take a particular form. So it can't be humanist. There have been numerous attempts to change the law on this and to allow humanist weddings. There were many attempts or many suggestions of reform in the late 20th century and in the early 20th century under what was called the New Labour government, led by Tony Blair. But none of that became law. There was a bill put before Parliament which would have opened up marriage law to all religious and non-religious groups, provided that they would register as charity, but that didn't become law. In 2013, there was an Act of Parliament, a bill, we call Acts of Parliament bills before they become law. There was a bill to allow same-sex marriage in England and Wales. And there were attempts as part of that bill to include humanist marriages. At various different stages as that bill was going through the UK Parliament, several attempts were made to put in provisions that would allow for humanist marriages. And you can see some of them there. There's more detail on this in the book. But at first, there was a provision put in, sought to put in, which would allow non-religious and religious marriages if the religious group and non-religious group met the good repute test. That was rejected because the government said that the bill was not the right vehicle for reform. The government suggested if you want to reform, go for something narrower. So the humanists did. They then tried for an amendment just for humanism. And then the government, the AG, the Attorney General, the member of the government responsible for law and order, said, no, that would breach human rights. That would breach the European Convention on Human Rights. At committee stage, they then went for an amendment for non-religious belief systems generally. The government said, of course, everyone will support humanist marriages, but they said not now because we need to think through the other ramifications. And so in the end, what happened was an amendment was passed to allow regulations to allow non-religious belief marriages to take place, but only after a review. So an amendment to simply allow regulations to exist wasn't passed. The amendment that was passed was an amendment to hold a review and then the power to hold such regulations later on. And that became Section 14 of the Same-Sex Marriage Couples Act 2013, which defined belief organisation as any organisation whose principal or sole purpose is the advancement of a system of non-religious beliefs that relate to morality or ethics. Note that a broader definition than the definition we found in Hodgkin, which talked about secular, has been excluded there from the definition of religion. The consultation took place. The majority were in favour of law reform, but a number of people said it would be difficult to outline the criteria to define non-religious beliefs without discriminating against some belief organisations. So the government said, we need to think about this even more. We need the Law Commission to do some work on this. So that was the reason for the Law Commission's initial scoping paper that I mentioned earlier. And again, the Law Commission said there's a clear need for reform for humanist marriages, but there's no simple solution, and there's a need for a full Law Commission report. So in 2015, they said that. Then the government did nothing. They declined to act. They said there are other pressing issues. 4 years later, the government wakes up and suddenly announces that there will be a Law Commission project. And then in September 2020, as we've said, the consultation paper was published and the full report is due later this year. But in between announcing the report in 2019 and the initial paper in 2020, there were a number of movements. The humanists brought more bills before Parliament and brought a case before the courts. And in the case before the courts, the Harrison case, the courts held that the current law breached human rights, breached the applicant's rights to freedom of religion or belief. But, they said, it was justified by the fact that the law was currently under review. The Law Commission then published their consultation paper. They, as I mentioned earlier, suggest this officiant-based system, but they said that officiants could be registration officers, so the civil servants, Anglican clergy, so members of the Church of England, Church in Wales, and then nominated officiants from any religion or belief body, or, and then fourth category, independent officiants. Now, their definition of a non-religious belief organisation uses the Hodkin definition. And so they define a belief organisation as any organisation that professes a secular belief system. But I would argue that definition doesn't work because there's some non-religious belief systems that are not secular. It also doesn't work because it doesn't tell us anything really about the belief organisation. And the Law Commission recognise this because then they say, well, there will also need to be other tests as well as meeting our definition. There would need to be at least 20 people who are members of the belief organisation, and the belief organisation would need to have a policy on and a belief on marriage, and we would also need to exclude certain beliefs, such as political beliefs, from the definition. These are requirements which I just mentioned. Now, I argue that these requirements show that the system that the Law Commission are proposing doesn't quite work. Because, on the one hand, you're saying that if I'm a humanist celebrant, I would need to prove that I meet the definition of, that humanism meets the definition of belief, and that I have at least 20 followers, and that I meet any other requirements that the Law Commission dreams up. Whereas, if I'm an independent celebrant, I do not need to meet those tests because I can simply go under the fourth head for individual application. Now, let me be clear here. I think independent celebrants should be legally recognised. I think that if you're extending the law to cover humanists, you should extend the law to cover independent celebrants. They are doing exactly the same service up and down the country, and people do not know the difference between a humanist celebrant and an independent celebrant. And so I think if you change the law just for humanist celebrants, or just for belief-based celebrants, and didn't change the law for independent celebrants, that would cause more confusion and more injustice, probably, than the current law does. But if you are allowing and legally recognising marriages by independent celebrants, then you can't limit officiants to religion or belief organisations. Because why should I, if I'm a celebrant, why should I, if I'm a humanist celebrant, have to prove that I've got 20 followers, whereas if I'm an independent celebrant, I do not? What that would mean is, I would simply say, well, okay, although I'm going to conduct a humanist celebration, a humanist wedding, I will simply call myself an independent celebrant. I'm not going to go through the rigmarole of going through the tests for a religion or belief, where I can simply apply individually and get the same thing more easily. So, in the book, I welcome the Law Commission's remove from buildings, but I query the definition of belief. And I say there are two options. Option one, have a more rigorous definition of belief. If you want to limit it to belief organizations and then have a separate limb for independent celebrants, you need to have a rigorous definition of belief. Or, and this is my preferred option, is you open it up to all organizations. And that, by the way, means that most independent celebrants would be able to be nominated, because most independent celebrants are not truly independent in that they do belong to some form of umbrella organization. And there are ways in which you can do this. Irish law gives a definition of secular body which could be used either to define belief organization or organization. In the book, I actually use that to put forward a definition which could be used. And there's basically the definition. We'll take you through it. But that's how I would solve it. And Irish law also gives you how you would exclude certain beliefs. And again, that's how I would do it. So the options in terms of non-religious marriages is either you go for specific reform, and that's the current stance of Humanist UK, the main organisation in this country, look in the private members' bills, seek in further cases, particularly if the Law Commission proposals are not enacted. Or you go for general reform of marriage law to include humanist marriages, which is what the Law Commission is proposing and which I propose in the book. So, to conclude, what are my proposals for reform? What are the main findings of my book? Well, as I said at the start, there's a number of intimate adult relationships now outside marriage law. Cohabiting couples, unregistered religious marriages, and non-religious belief marriages. I argue that the Law Commission's work on this should be followed because it would reduce the number of unregistered religious marriages and could, with revision, and again, revisions are as outlined in my book, solve the issue of non-religious belief marriages. But it would do nothing for those who cohabit without any form of ceremony. So I think we need to look further back at the Law Commission's work. And in 2007, they looked at the law on cohabitation. And they said there's a need for opt-out cohabitation rights. And so in the book, I look at this and I look at what other jurisdictions have done in relation to similar cohabitation rights. And I argue we need this as well. This would not recognize unregistered religious marriages as marriages. This would not recognize non-religious belief marriages as marriages, but it would provide a remedy for such couples on relationship breakdown. If they'd been together for a certain amount of time and there had been an economic detriment to one party because of the relationship, perhaps they'd given up work to look after the kids, for instance, then this type of system would provide a remedy for them and would mean that they were not left outside the law, which is the current situation. So in my book, I argue we need a modernized marriage law, which reforms the law on how people get married to get rid of the discriminatory requirements about buildings, which treats all religions the same. But we also need a law of intimate adult relationships, which recognizes some limited cohabitation rights on separation. And if we did both of those things, then that would provide redress for all three of the problems which I've highlighted this afternoon: cohabiting couples, unregistered religious marriages, and non-religious belief marriages. And that is the argument put forward in the book, which is available now from Bristol University Press. And if you order it from the publisher, then there is a 20% discount at the moment. Thank you very, very much for listening, and thanks again for the invite. It's been an absolute pleasure to talk to you this afternoon. I'm now happy to take any questions that you have, and I will stop sharing my screen so I'm able to see you once more.
So is there any questions?
Question is question I want to ask.
Madam, if there is someone else before me, let him go ahead. I have a question, a specific question for Professor Sandberg.
Sir, you can ask questions. Dr. Vidha, sir, you can ask.
Oh, sir, thank you, sir. At the very outset, sir, I must say that the privilege was ours. It was such an engrossing presentation by Professor Sandberg. Sir, I have a specific observation about your presentation. If I may start on a lighter note, I was being reminded about the 16th century English writer and parliamentarian John Lilly, who said that marriages are made in heaven but consummated on earth. But sir, you showed so well how marriages, even after being made and consummated on earth, probably, how often they fail to be documented in law. But sir, I'm curious about one perspective as I was listening to your presentation, that marriage as an institution has quite a few bindings as well. For example, the question of the compensatory payments, settlement payments when it comes to a divorce, etc. And maybe that's one of the major reasons why many marriages remain unregistered in accordance with law, particularly by men in a male-dominated society. But in some countries, for example, France, for example, there are state incentives to, I would say, incentivize marriage registration, marriage documentation, like they give exemptions in income tax rates, etc. They extend monetary support to the families, provided they're recognized as married families. So I'm curious to know whether there are any such incentives, etc., in the United Kingdom, so as to incentivize more and more people, regardless of their religions, to have their marriages registered, sir.
Thank you. That's an excellent point. Yes, you're perfectly right in terms of, the major issue, as you were saying, was the access to financial remedy on what would otherwise be divorce. There are some limited tax incentives which have been introduced in recent years in England and Wales, but they are very limited, and I don't think has made much of a difference in terms of the debate. But yeah, that's another way to deal with this, would be by that. I mean, we've got quite a mixture of different laws which recognize different types of relationship. So there are some laws which do recognize some aspects of cohabiting relationships. So for instance, in terms of on death, there's some recognition of a cohabiting partner, but not to the same extent as a marriage partner. But yeah, the law is very, very inconsistent. But that would be another way around this. Yes.
Right, sir. Thank you, sir.
Thank you so much. May I ask a question?
Sure.
Hello?
Welcome, sir. You can ask a question.
Yes. I am Randhir Kumar Gautam. I teach sociology in Raffles School of Law. So my question is deeply engaged with the perspective of sociology. You know, first of all, what I think about marriage that I have already put in the chat box, marriage is being treated as a technical status, not as a particular practice. The discussion of what marriage is and how it is practiced will probably never get a hearing, but people will vote with their feet and decide not to marry if the practice is too constraining. My question is, you know, if you understand marriage sociologically, and you have also incorporated some sociological insights in your book, the marriage becomes the site of intergroup interaction or continuity of two grouping distinguished on the basis of gender. Very famous sociologist and social anthropologist Levi-Strauss famously said that you do not marry a person, you marry their kinship group. This makes more sense to me than the marriage represents the juxtaposition of the two between genders. But consider the marriage has nullifying effect for each person towards all other members of the opposite group, which is not the same in laws. Though there is a certain similarity between there are taboos on interacting with certain in-laws, the braided mother-in-law, for example, the mother's brother, right? So in that context, marriage has becoming extremely controversial. People are pressured, as I have one of the discussants already underlined. Many part of the country, because of the decrease of the population rate, they are enforcing marriage and accordingly, change the marriage law for that matter. But I have observed, my observation is United Nations. Almost if you see every film, television drops hint in some way that not to marry or to treat your spouse improperly will result in a serious punishment, which is often appears as an accident. Entertainment services as warning system. Yeah, if you go to United States of America, there are billboards on the highway, and it is written there, what have you done for your marriage today? I was just browsing a website called foryourmarriage.com, and in just past 30 years, the marriage rate had dropped 98% of adults to 60%. The divorce rate has held steadily at whopping 60%, but the remarriage rate has plummeted and going slow in now the preferred lifestyle among the over 50 crowd. In China, because of the gender discrepancy, you find 50 million males more than marriageable. Even 75% of the black children, 50% of Hispanic children, and over 25% of the white children are born outside the marriage in India. So outside the marriage in United Nations. So my question is, to you, that how do you evaluate the marriage system of United States of America? Because with the advent of right-wing government, we are observing the religious light is given, and with the advent of, say, Democrats, we are again seeing the protest of changing the law. So how do you see, because the matter is not with the religion in the marriage law,
Sir,
the
please,
matter is
brief
with
your question.
ideologies. So this was my brief observation I would like to comment on this very issue. Thank you so much.
Okay, thank you so much.
Thank you very much indeed. Yeah, you're absolutely right in terms of the disarray between the sociological and the legal here, which I think is probably true in most jurisdictions, because adult relationships and the way in which they're formed and formalized and function often moves quicker in sociologically than legally. I think that's the issue. And you're right, it's not just an issue for religions and religious leaders, it's an issue for legislators, it's an issue for the public. I mean, in relation to the American situation in particular, I don't know enough about that to be able to comment. But as a general point of then, yeah, I would imagine the case study that this book represents is probably replicated elsewhere with different problems, different issues, and also would be duplicated across time with different issues and different problems. But nevertheless, probably there's a constant uneasy tension between the letter of the law and the social practice.
Mr. Answer, actually, I have a question. Mr. Sandberg, I am very thankful for you. You have given a lot of awareness of the marriages. Actually, I want to tell you that we are running here Marriage Support Center, and we have been solving domestic violence cases. More than 80 cases I have solved here. My keen observation on this side, I want to tell you that in your talk you have mentioned that we need to give space for the adult relationship to cohabit to some extent. So my argument on this, if we give some space for the adult relationship to cohabit, don't you see that it leads to the rape? Because the marriage is not solemnized. And one more thing, I'm going to tell you that as per the IPC, the British government made the IPC in olden times in a country in India. So the Apex Court, the Supreme Court of India, has abolished the IPC, which was a provision under the section of 497 Adultery Act. So I'm dealing one case of the rape of one scientist. Actually, he had cohabited with a previous partner, and the partner put a case in Hyderabad saying that he has raped, though they cohabit. So this kind of cases are being occurring. What's your opinion on that?
Well, I think obviously that's concerning, and I think that also again comes back to the point I was just making about the sort of the interplay between the legal and the social not working out. But I think it's such a matter of cultural and social issues on the one hand, but it's also a matter where there is a real need for a firm line being drawn by the law in order to protect victims. So yeah, I mean, again, not knowing the detail of the particular issue, I wouldn't want to comment in detail on that, but as a general point, I think that underscores the sort of the general thesis here, which is the need for accessible, clear, equal, and fair rules. Because as you're saying, there are important ramifications of these things.
Kind of some technical issue.
Can I ask a few questions, sir?
I want to continue by saying that don't we solemnize the marriage, because the marriage is the, it's a sociological and a contract based legal entity. As you said that the adults should be in the relation, but unless they are not solemnized, how they can have their rights and duties over, like the husband and wife, they have rights and duties? How the society will recognize them? That's my question.
Oh, yeah. Right, but there's a kind of possibilities there. You could go down, and one thing the book doesn't do is the book doesn't look at sort of impractical hypotheticals, like a bit like that. I focus very much on what are possible reforms in England and Wales. But it would be, as a hypothetical, you could go down the route of not recognising marriages legally at all, and having unions that exist sociologically, and you simply then recognise the effects of them. You simply recognise remedies in relation to children, remedies in relation to buildings, etc. In terms of how a law on cohabitation could work alongside a law of marriage in England and Wales, if that's the question which I think you're asking, in terms of that, then the law of cohabitation would simply provide a backstop and would give rights in a situation where I've been living with someone for 5 years. As a result of that, my partner has given up work or has reduced the hours that he works, or has undergone some other detriment. And so if that relationship broke down, under cohabitation rights, you could then go to court to get a financial remedy. So it's not anywhere near the rights you'd have in relation to marriage. It's not recognising the relationship as such. What it's doing is it's recognising that there has been a detriment to one party, which needs to be recognised on relationship breakdown. If that makes sense. I'm not quite sure whether that does answer your question or not.
Actually, I didn't satisfy with the argument which you have made. My single question, just simply, as the marriage is between the two parties, as the civil right is concerned. So how the rights occurs between the husband and wife as they are not solemnized?
Right.
They must be solemnized, as the society has to recognize them as an identical husband and wife.
You can drop your question, okay? And whatever you are like asking, its answer is very much simple. That we need to study the content or intention of the the spouse. So if their intention is to live together, we will take them as a couple, and accordingly, Supreme Court or we will treat them. So this answer is very simple. The intentions are really important. Okay.
Yes, so maybe she will not be regarded as wife, but partner. Partner, the status of partner itself is.
Yes. Supreme Court can, the High Court and Supreme Court can give them, maintenance and other things.
Yes, they are.
Yes, sir.
Yes.
Can I ask a question?
Any other person who wants to ask questions? Because we are, yes, I can take on.
Arun sir, I have a question.
Can I ask a question, sir, please?
We can take only one question. You can drop your question on chat box.
Arun sir, may I ask a question?
So why there is a need of responsible court in countries like India for marriage laws?
Who wants to ask a question?
Hello. Am I audible, sir?
Yes, I.
Wait a minute. I just want to clear one thing. That sir is having expertise on British marriage law.
Yes.
So if you have any questions regarding the Indian legal marriage system, you can better drop your question, and definitely I will give you answer of that.
Okay, sir.
If you have any question related with Indian marriage system, if you have any doubt, you can drop your question and I will answer you.
Yes.
Okay, sir, I have dropped the question. I expect the answer from you, sir.
Yes, sir, you can drop your question on chat box. I'll be more than happy to give you answer. Okay, Sabir.
So now I would like to invite our HOD School of Law for vote of thanks. Please, sir, over to you, sir. Unmute, sir.
Good afternoon, everybody present here. My name is Arun Verma, and I'm the head of law at School of Law, Raffles University, Nimra. It is my honor and privilege to extend a vote of thanks on this August moment. I would like to thank Ms. Sabiha Khan, Faculty of Law, Raffles University, the convener of this webinar, for giving me this opportunity to extend my vote of thanks. On behalf of School of Law, Raffles University, Nimrana, Rajasthan, India, I would like to thank our distinguished guest and speaker of the day, Professor Russel Sandberg, Professor of Law at Cardiff University, UK, speaker of today's webinar, for his thought-provoking deliberations on the topic religion and marriage law, the need for reform. Thank you, sir, once again. We are grateful to our chief patron, Revered Dr. Justice Meena Vigombar, for being the source of inspiration and motivation for organizing such kind of activities. I would like to express my sincere thanks to Professor Diwakar Goli, Honorable Vice Chancellor of Raffles University. I extend my vote of thanks to active participant, guest, audience, and everybody who contributed in making this program materialized. Finally, thanks a lot once again to everybody, and I wish you a happy time. Goodbye, take care.